Hello, everyone, and welcome to today's webinar, 1 Year of Labor, What's Changed in Compliance and What's Coming. I'm Naomi Grossman, Compliance Manager at VinciWorks. And you may be able to tell that I'm American. I'm not sure what's going to give it away, but it might be something you hear. Don't let that put you off, because here at VinciWorks, we've been closely following the parliamentary ping-pongs and major compliance changes from Westminster. And I'm joined in this today by Sarahana Dahan, also Compliance Manager at VinciWorks. Also, you might be able to tell an American, but it's great to have you with us today, Sarahana.
Thanks, Naomi. That's right. I am originally from Boston, but we have been following the important changes in British legislation for a long time. And it is a bit of a nice relief from American politics. That's the truth.
Could not be more true. But we do have a Brit with us today, Raquel Shepson from VinciWorks, who works tirelessly to help our clients understand their compliance obligations.
Thanks, Naomi. It's so great to be here. Yeah, I'll be repping North London for today's webinar.
Wonderful. Fantastic to have you with us today, Raquel. And you are responsible to correct us if there's any issue with our pronunciation.
I will do. Don't you worry.
We really want to hear from all of you during today's webinar. If you have any questions, any comments, or an experience of some of these issues that you want to share with us, please let us know in the chat or the Q&A. And we are going to try and respond to some of those as we go through. Of course, if we don't get to your question over the next hour, we will get back to you by email. And please feel free, use the chat function, use the Q&A on Zoom. We really want to hear from you. And just a reminder again, the session is being recorded and you will get a recording automatically after the webinar. Also, VinciWorks has a number of training and software options to help with compliance across all of these critical areas we'll be discussing today, and we're discussing quite a few. So if you want to see any of those options, please write demo in the chat and we'll be in touch with you to show you more about those. This is actually our last webinar for the summer until September, where we'll be back with some very critical compliance issues. It's going to be a really good way to start off the year. On September 3rd at 12 p.m. UK time, we have failure to prevent fraud, complying with the new corporate offense. A link to register for that webinar is coming up in the chat now. On Wednesday, September 10th at 12 p.m. UK time, we will have a webinar on the Data Use and Access Act compliance. What's changed in UK data protection? Really, really important. Coming online, you are going to want to know about that. Link to that webinar is coming up in the chat also. Okay, we finished with all our housekeeping. So it's been quite a year in the world of compliance. Now, before we jump in, we really want to hear from you. Let's start with a quick poll to understand, what do you think about the compliance changes so far from this Labour government? The poll question is, do you approve or disapprove of the government's compliance changes so far? Do you approve, do you disapprove, or are you not sure? Again, the question, do you approve or disapprove of the government's compliance changes so far? Approve, disapprove, not sure. We'll give everyone a couple of seconds to answer. Also, let us know in the chat why you think this. We're going to try and read out some of your comments as we go through. So share with us. Now, really interesting. 27% of you approve of the government's compliance changes. Only 4% disapprove. Really interesting. An overwhelming 69% of you are just not sure. So you need a little more time to see what's going to be. Thank you. Really, really interesting. So let's get started. It's been just over a year since the Labour government took office. They campaigned on the platform of a new deal for working people and stronger corporate accountability. Now, in July 2025, we can ask, what has Labour done so far that has impacted compliance? One of the headline changes we've seen is in data protection. Labour introduced and passed the Data Use and Access Act, which just became law last month in June 2025. This is a major overhaul of data protection rules. Sarahana, Can you tell us what this act changes and what does it mean for organizations?
Yeah, of course. So, good question. The Data Use and Access Act is a significant update to the UK's data protection regime. In many ways, it builds on the existing UK GDPR framework, but there are a few important tweaks. For example, it altered the rules around automated decision making and the use of legitimate interests as a basis for processing data. So, previously, purely automated decisions, that would be those made without human involvement that have a legal or similarly significant effect on individuals, were heavily restricted. Now, the Act refines those restrictions, possibly allowing more flexibility in AI-driven decisions under certain conditions. So organizations will need to review any AI or algorithmic decision systems to ensure they comply with the new standards on transparency and fairness. Now, another change is that the Act introduces greater access to public sector data for business use. This is part of a push to spur innovation by allowing businesses to make use of government-held data sets. While that's more of an opportunity than a burden, it does mean that if you're in a sector that could benefit, you will want to ensure that you handle any such data responsibly and within the law.
Thank you. That's really, really helpful. And what do organizations need to do to take advantage of these new flexibilities, but also make sure to keep on the right side of compliance?
Yeah, so that's a great question. It definitely can be tricky, but I would say retraining on data protection is going to be really essential across most sectors. All those little rule tweaks mean that what your staff learned about data protection a few years ago might no longer be fully accurate. So, for instance, the definition of legitimate interest has shifted. So the basis on which you justified certain data processing might now need revising and revisiting and possibly revising. If your marketing department relies on legitimate interest for contacting leads, for example, you should double check that those activities still fall within the new parameters.
For sure. So I want to add here quickly that organizations should also pay attention to guidance from the ICO on these changes. This is because often after big data law passes, the regulator will issue practical guidance or update their code of practice. So that can help clarify grey areas like what counts as an automated decision making with a significant effect under the new act. You also have to remember that all of VinciWorks training courses on data protection have been updated with the new legislation. So it's great because it means you don't need to go through the course yourself and mark up training. So if you use VinciWorks already, along with new courses on this law specifically, it's all ready to roll out to your staff.
Wow, that's great. Thank you. Excellent, excellent points and really good advice from both of you. So if you're involved in managing data privacy, you should make a note. Review your automated decision-making processes, update your legitimate interest assessments, and retrain your staff on the new rules. It's a lot, but it's always better to be proactive. Okay, Raquel, let's move to an area that affects quite literally every single business: employment law and harassment protections.
Thanks, Naomi. So that's completely right. So Labour was elected with a strong workers' rights agenda. The flagship here is the Employment Rights Bill, which has not quite been passed yet. There is still some back and forth over exactly what will be included when it comes into force, but this legislation touches many aspects of the employer-employee relationship. So some of the headline changes are around day one employment rights for all workers. So things like unfair dismissal protection, parental leave, and sick pay won't actually require a 2-year waiting period. So that's really interesting. They'd be available from the first day of employment. Although I should say that the House of Lords actually voted last week on those proposals and rejected these rights from day one, but instead voted to bring the protections in from 6 months instead of the current 2 years. So there's still kind of a movement in that. However, I doubt the government will give in on this since it was a manifesto commitment. So we're probably in for some more parliamentary ping pong, I'd say, before the actual decision gets made.
Wow, it's really interesting to follow the political back and forth, but it's unusual for the House of Lords to outright reject a proposal that was in the government's manifesto. from what I know. So like you said, Raquel, I would imagine the government will probably or eventually get its way. So another thing the Employment Rights Bill requires is more tracking things like holiday pay and time off. How's that supposed to work?
That's a really good question. So there will be new obligations to ensure workers, and especially those with irregular hours or in the gig economy, don't miss out on holiday pay. So this means employers will have to track and compensate for holidays and holiday pay properly. So it doesn't add any new holiday rights, but it is important for payroll compliance. The Employment Rights Bill is going to make bringing an employment tribunal claim easier, and it will extend the time limit to bring an employment tribunal claim from 3 months to 6 months. It also removes the lower earning threshold and waiting period for statutory sick pay. So more workers will qualify for SSP, and they'll get it from day one of illness rather than waiting several days. So this means ensuring your payroll system is adjusted and budgets for potentially higher sick pay costs.
Oh, it's really, really important to know. And there are dozens and dozens of specific changes in the Employment Rights Bill. And I know we don't have the law yet, but we do have a very good idea of what will be in most of it. So you can download our guide to what will be in the Employment Rights Bill Act. It's coming up in our chat now. A link to the guide is coming up in our chat now. And we will, of course, update this guide once we get the final legislation. Now, Sarahana, another critical area to highlight is the changes to harassment in the Employment Rights Bill. Can you kind of walk us through that?
Right, of course. Thanks, Naomi. So, yeah, we already had the Worker Protection Act from 2023, which required organizations to undertake a risk assessment and put in place reasonable steps to prevent sexual harassment. Now, this is being enhanced to require employees to take what they're calling all reasonable steps to prevent harassment from happening in the first place. And if they don't, they could be held liable. So previously, an employer could use the defense that they had taken reasonable steps if a harassment claim was brought. But now it will be an affirmative obligation to have those steps in place before anything even happens. And that is a significant shift. For compliance, it means that every organization should be reviewing their anti-harassment policies, training, and reporting mechanisms now. So you got to ask, do you have a robust training program that all employees go through? Is there a clear policy and culture that discourages harassment? Are there multiple channels for reporting issues? Do you act on reports promptly? These are the reasonable steps you will want to have evidence of.
Wow, excellent. So important. And it's actually another thing we can help with. We have a guide to the Worker Protection Act, and a link to this guide is coming up in our chat now, so you can download this guide. It has so much information about these kinds of reasonable steps employers need to put into place to be compliant. So let's ask our audience, our webinar audience right now about this. This is our second poll question. How prepared are you for proactively preventing harassment? Are you fully prepared? Are you somewhat prepared? Are you starting preparation soon? Are you not prepared, or you're not sure? Really, really want to hear from you, and let us know in the chat if how you are prepared, how you are not, or any other thoughts you have about this. Again, the question, how prepared are you for proactively preventing harassment? Fully prepared, somewhat prepared, starting preparation soon, not prepared, or not sure? Give everyone a couple of seconds to answer. Okay, really, really interesting. 20% of you say you are fully prepared for proactively preventing harassment. It's fantastic. 51% of you, a little over half, are somewhat prepared. Only 8% of you say you're starting preparation soon. 8% of you say you're not prepared, and 13% are not sure. So interesting results. This is also a really good time to mention our new suite of courses that we have to support the implementation of reasonable steps to prevent harassment. So we've recently launched a brand new AI-powered conversational learning courses covering a range of topics, and that includes sexual harassment. And these courses, I've done these conversational learning courses, they're incredible because they're extremely intuitive and they adapt to your level and what you know. So, and they're very effective. They encourage users to engage in discussion rather than just learning definitions. Users are given a series of workplace scenarios and you have to reflect on them, and then you're even challenged on your reactions. You have to justify how you would respond, and you have to navigate some really complex or kind of borderline harassment cases. So we actually have a video about conversational learning courses, and that's coming up right now. It's a couple of minutes, and you're really going to want to see this.
Way we did it in my last one.
Hi, so cool. That was kind of a short trailer about our conversational learning style courses. And that was covering a range of compliance topics, from sexual harassment to bribery, money laundering. If you want to see more of these, write CL into the chat now and someone will be in touch. Okay, so let's move on to the topic of financial crime and corporate fraud, which is a big change coming in just over a month on September 1st. Sarah Henna, can you tell us about that?
Right. Of course. Yeah, that's exactly right. So we have a new corporate offense, failure to prevent fraud. And this was brought in as part of the Economic Crime and Corporate Transparency Act of 2023, passed by the previous conservative government, but it comes into force on the 1st of September, 2025. In just a bit over a month. So it means that large organizations can be held criminally liable if they fail to prevent fraud by an employee or agent for the benefit of the company. So it is similar to the existing failure to prevent bribery and failure to prevent tax evasion laws. But now companies need to have reasonable procedures in place to avoid fraud, to actively avoid it. And that means, for example, risk assessments, internal controls, employee training, whistleblowing channels to report fraud, and due diligence on partners. And now, even though it's not active until September, guidance and enforcement direction are already shaping organizational efforts now. So the prosecuting authorities have been giving strong hints about what will be coming. So compliance teams should treat now as the deadline to implement anti-fraud programs. Because if you wait until a fraud incident happens after September, when it has actually come into place, that's going to be too late. By then you could be prosecuted if you didn't already have prevention measures in place in advance.
Wow, that's really, really good advice. So it's kind of urgent. And basically, yeah, Raquel, right now is crunch time to get those anti-fraud measures in place.
Exactly. It's 100%. It's very, very urgent. From the 1st of September, if you're covered by failure to prevent fraud, you should be able to demonstrate that you've assessed fraud risks and put controls in place. So that's the good thing. But we should all be aware that this might involve quite a bit of cross-department collaboration. So we're talking finance, legal, operations, HR. They should all be on board. And importantly, training employees to spot and prevent fraud is a huge part of those reasonable procedures. So if you haven't rolled out fraud awareness training to your staff yet, that should for sure be a priority in the coming weeks.
Yeah, really, really, really important advice. And this is something Labor really committed to tackling in the run-up to the election. And they've also shown quite a strong will in government to crack down on corporate fraud and tax evasion.
Absolutely. We're already seeing a more aggressive enforcement stance. The Serious Fraud Office and the FCA have stepped up enforcement already. They've stepped up actions over the past year. There have been high-profile investigations and fines. So, for example, Metrobank, Monzo, Barclays, and multiple law firms have faced penalties for various compliant failures, from AML to sanctions. In the Chancellor's spring statement in March of this year, we heard that the government is committing to introduce new criminal and civil penalties for breach of disclosure of tax avoidance schemes. So that's basically the scheme to crack down on aggressive tax avoidance. And they're even going to cut down on legal privilege for law firms that provide opinions supporting tax avoidance schemes. So that's a really interesting kind of add-on. Tax advisors and banks could be prohibited from enabling transactions relating to tax avoidance schemes and have to report any suspicions to HMRC. We haven't had the details of the legislation yet, but it will for sure be quite a big new compliance burden on those kind of firms.
Well, so really have to keep an eye on that. Now, another promise from the government is the recent announcement of a change to money laundering regulations. Sarah Hannah, what can we expect there?
Good. Thanks for bringing that up. Yeah, that's going to be really important too. And there are a few things going on there. So first is the updated national risk assessment for AML that's just been published. There are a few changes to be aware of, like trust in company service providers rising from low to medium risk over concerns around beneficial ownership transparency, and enhanced due diligence requirements have been tightened for complex transactions and high-risk countries. And then on top of that, as part of the wider industrial strategy, the government has committed to amending the money laundering regulations by the end of this year. So we are waiting for the legislation to be published, but based on the consultation response, we already know that we are likely to see some changes, like consolidating EDD regimes into a single framework, which would be helpful, and some clarification on source of funds checks, and also some movement around digital ID, which we know the government is very keen on.
Well, there's really a lot to keep track of when it comes to AML changes. And just a reminder, we have our up-to-date guide to all of the countries considered high risk by the FATF and the EU. This is an incredibly comprehensive guide. You can download a link that's coming up in the chat now. And this is a guide to all of the countries that are considered high risk by the FATF and the EU. So now let's ask you, the audience, about failure to prevent fraud, because it's coming so soon. Now, our third poll question is, how prepared is your organization for failure to prevent fraud? Fully prepared, some are prepared, making progress, not started, or not sure, just not applicable? We want to hear from you. How prepared is your organization for failure to prevent fraud? Fully prepared, some are prepared, making progress, not started, or not sure, not applicable. And again, pop into the chat if you have any comments or insights or experiences you want to share about this. Let us know, though, how prepared your organization is for failure to prevent fraud. Give everyone a couple more seconds to answer. Okay. These are really interesting results. 10% say you're fully prepared. 41% say you're somewhat prepared, which is similar to the previous poll question. 16% say you're making progress. 12% have not started. And 22% of you are not sure, or it's just not applicable. So thank you. Really interesting results. Now, let's talk about another aspect of compliance that's seen a raft of change, although not necessarily all from the government, and that's the world of diversity and inclusion. It's been going through some significant changes, some even sparked by court cases. Okay, Raquel, what's been going on?
Right, so you're completely right. There have been a lot of changes. One of the biggest developments in equality law was actually a judicial one. So the case is called for Women Scotland, which clarified the definition of sex in the Equality Act. The Supreme Court said that at any time the Equality Act refers to sex as a protected characteristic, it actually means only biological sex, so male or female, and not gender identity. This might sound sort of abstract, but it does have concrete implications that organizations should be on top of. It means things like policies around single-sex spaces or activities, language and diversity surveys, and how transgender issues are handled must align with the ruling that sex is biological.
That's really interesting. And it's also impacted things like data collection and diversity monitoring, hasn't it, Sarah Hannah?
Oh, it definitely has. So a very tangible impact was when the Solicitors Regulation Authority, the SRA, which oversees law firms, had to update its diversity survey for 2025 to align with the ruling. Now, we actually offer a free tool for law firms to collect and submit diversity data about their workforce. And we also had to make changes when the SRA changed the questions on sex and gender to reflect biological sex as distinct from gender identity. So essentially, firms had to ask employees about their sex registered at birth in line with the clarified legal definition and handle gender identity separately. Now, for compliance officers beyond the legal sector, the lesson from the For Women Scotland decision is immediate. Review your policies and procedures. That is the advice. So if, for instance, you have an internal survey or job application that asks for gender in a way that could be misconstrued, you might want to separate that into sex, so male or female, and an optional question on gender identity rather than a combined field, which you may have had before, to ensure that you're capturing the data you might need for any official reporting to make it in line with the Equality Act as it stands now.
Thank you. Really, really good advice. So, Raquel, what else are Labor planning around equality and diversity?
Good question. So Labour have talked about reintroducing the concept of dual discrimination into the Equality Act. So this means a person could bring a single claim for discrimination based on a combination of characteristics. So right now, claims usually have to pick just one ground, which can obviously miss the intersectional nature of discrimination. If the government enacts this, employers will need to be aware that discrimination complaints might not fit neatly into one box. So your investigation and training should acknowledge these subtleties. It could potentially make tribunal cases a bit more complex, but also more fair to claimants who experience overlapping biases. Also, we're going to get a consultation on expanding gender pay gap reporting requirements to disability and ethnicity. This is really, really important for large firms who already have to report on the gender pay gap, as they'll need to monitor and report additional pay gaps. We are actually expecting to see legislation introduced on this later this year, so it's definitely worthwhile starting to think about this now if you do already report on your gender pay gap.
Also, really, really, really good advice. Thank you. And although that is still in the consultation phase, we do have a guide on exactly how to monitor and report on the ethnicity and disability pay gap. A link to this guide is coming up in the chat now. Really, really helpful, especially based on the advice that you're receiving here. We also have software that can help you do that. You can write OmniTrack into the chat to learn more about our data collection tools, which can really help you to keep track of this. So write OmniTrack into the chat right now, and you can learn more about our software. Now, Sarahena, we can't forget about the issue of menopause, because this has become a flagship policy of the Deputy Prime Minister.
Oh, yes, it definitely has been a key issue indeed. The Deputy Prime Minister, Angela Rayner, had previously promised plans for a statutory right to menopause leave. That means a certain amount of paid leave for women suffering serious menopause symptoms. Also, large employers will be required to develop and publish menopause action plans, and these action plans would outline how the company will support employees going through menopause, whether it's flexible working options, temperature control in workplaces, uniform adjustments, training for managers to understand menopause, things like that. And they'd likely have to be updated annually or even submitted to the government, potentially through the same portal used for gender pay gap reporting. So we haven't actually seen concrete legislative proposals yet, but from a compliance perspective, if you don't have anything addressing menopause, it could eventually become a compliance gap. Now, also under the current law, menopause symptoms can qualify as a disability for Equality Act protections and reasonable adjustments. And we have seen tribunals where women who weren't supported through menopause did win claims for discrimination and or unfair dismissal. There was just a case recently that we reported on where a woman won nearly £30,000 from the Ministry of Justice that discriminated against her because of her menopause symptoms. So menopause issues should be treated as both a current risk and likely a future formal requirement.
Yeah, that's really important. And that was a really, really interesting case. So thank you for that.
Yeah.
Really, really important for everyone to know. Now, there's one more big court case impacting diversity and inclusion, and we should really cover it because I know it has serious implications for things like free speech and discrimination at work. So, Raquel, can you tell us about the Higgs versus Farmers school case?
Of course. Thanks, Naomi. It's a really, really interesting case. So this was a Court of Appeal case, which the Supreme Court recently upheld. The case affects all workplaces, even though it took place in a school, which is important to keep in mind. In this particular case, a Christian school worker was sacked for making a personal social media post about gender and sexuality. The school said that some people might find them offensive, even though it hadn't actually received any complaints. But the court said that her beliefs were protected, as was her right to freedom of speech, especially outside of the workplace. Cases like that and some high-profile tribunal payouts means organizations must really, really ensure their policies are aligned with people's legal rights to things like free speech and just not discriminate against people for expressing lawful beliefs. There's actually another employment tribunal going on at the moment with NHS Fife over a nurse called Sandy Peggy. So Sandy had objected to sharing a changing room with a biological man who identified as transgender, even though the changing room was supposed to be a single-sex place. It's a really interesting case because the DEI team at NHS Fife has come under serious scrutiny during the tribunal for being unable to defend their risk assessments, which had no regard for the rights that women have to single-sex spaces under the law. So these cases are a really important reminder for compliance officers to ensure your inclusion policies don't punish or discriminate against people for their beliefs. It's a nuanced area because you have to prevent harassment and bias, but also not just become the thought police.
Yeah. Oh, it's such a complex area. Absolutely. And we have a guide to navigating some of these issues. A link to the guide is coming up in the chat now. And it's a guide to free speech and protected belief at work. And really, really important. You just need some guidance on how to navigate these really, really complicated situations. So a link to that guide is coming up now in the chat. Before we move on, it would be really great to see how people are managing their DEI training with so many changes going on. So the question is, how effective is your DEI training for complex issues? Very effective, somewhat effective, it's okay, but could be better, not effective, or you don't have DEI training. Again, poll question. Really want to hear from everyone here. How effective is your DEI training for complex issues? Very effective, somewhat effective, okay, could be better, not effective, or you don't have DEI training. And again, if you have any comments or insights or questions, pop those into the chat. We'll try to respond here, or if not, we'll get back to you on email. So how effective is your DEI training for complex issues? A couple more seconds to answer, and then we'll give you the results. Okay, really interesting. 11% of you say your DEI training for complex issues is very effective. 32% say somewhat effective. 36%, which is the highest percentage in this poll, say it's okay but could be better. 0% believe it's not effective, which is good. And 21% of you say you don't have DEI training, which is interesting. So thank you for that. Thank you for your responses. And just a quick reminder that VinciWorks conversational learning style is perfect for these complex, nuanced issues and is automatically updated with new legislation and case studies as these regulations evolve, and they are and they will. So if you want to see more of that training, just write CL into the chat. Okay, now let's gaze into our crystal ball and look at some of the upcoming changes and developments in compliance we're expecting over the next few years. First up is sanctions. What do we expect to see in that area, Sarhana?
Okay, so yeah, that's a big one. The UK government recently concluded a review that the UK could be doing better on enforcing sanctions. Ministers are now proposing several measures to bolster sanctions compliance and enforcement. So we are likely to see things like new civil penalties for sanctions breaches. So regulators like the Office of Financial Sanctions Implementation, OFSI, could impose fines more easily for companies that, for example, make payments to a sanctioned entity. They're also looking at a settlement mechanism, possibly similar to the US OFAC model, where companies can settle breaches rather than face drawn out court processes. And interestingly, they want to add whistleblower protection specifically for those who report sanctions violations. So if an employee blows the whistle at that their company is trading with a sanctioned party, that whistleblower should be protected from retaliation. Now, this is quite important for compliance because sanctions have often been seen as a kind of niche area, but with the war in Ukraine and other geopolitical issues that have been going on in the past few years, it's become mainstream. So companies must have robust sanction screening and monitoring. If civil fines become more common, then even an inadvertent slip, like paying a Russian bank that's on the sanctions list, could result in a penalty. Whereas in the past, the UK might have only given a warning for minor breaches. All signs are pointing to the fact that that is no longer going to be the case.
Right. Really, it's really, really important to know. And like you say, the world is only getting more complicated. So it's becoming important. And it's also not the only area where senior managers in an organization could find themselves now personally liable. Is that right, Raquel?
That's completely right. Exactly. So the draft crime and policing bill has very, very important provisions that will be pretty significant for compliance teams in this area. So the legislation, which is currently going through Parliament, will extend senior managers liable to any criminal offence. This is really important as it will make top executives personally accountable if their company commits any criminal offence, not just specific ones. So right now, senior managers can be held liable for specific things like involvement in fraud or bribery, but this proposal could cast a much, much wider net. So, for example, if a company breaches, let's say, health and safety laws, leading to a death perhaps, the CEO could face charges even if there wasn't direct involvement. It's a really dramatic expansion, and it's certainly intended to make managers very, very attentive to compliance in all areas.
Oh, I am so sure that will make them really, really attentive. That's a very, very dramatic change. What do we think the impact of this will be on compliance teams?
A really good question. So for compliance officers, this is kind of a bit of a double-edged sword. So on one hand, having these laws can really help you make the case to leadership that compliance must be taken seriously. But on the other hand, it means we need to ensure our senior managers are properly trained and informed about their duties and what's happening on the ground. So they should actively support compliance efforts and not just assume the compliance department will shield them.
Yeah, it's really important. Thank you. And next up, let's look at the future of cybersecurity. It's also been a year of big changes with the Data Use and Access Act. And we've had major fines and breaches like the Marks and Spencer's hack, and even this Afghanistan data breach, which was in the news recently after the super injunction was lifted. And that's an incredible and kind of crazy story. What else is coming, Sarah?
Yeah, so big stories there and so many crazy, just huge stories of cyber breaches lately. And the government does have a cybersecurity and resilience bill drafted. That's expected to be published after summer 2025. The aim is to make cyber resilience a core compliance duty, not just an IT issue. So we anticipate it could require companies to meet certain cybersecurity standards, perhaps report cyber incidents in new ways, or have formal cyber resilience strategies. Now, for compliance officers, this means that you might be more directly involved in cybersecurity governance. Whereas traditionally, many companies left cyber to the IT department. Now, this legislation will likely mean that cyber resilience becomes a board issue and creates liabilities for failing to protect data systems. It means compliance will have to work hand in hand with IT and risk management to implement frameworks like ISO 27001. It's a good idea to start reviewing your cyber incident response plans and data breach protocols now. So a good question to ask yourself is, if a regulator knocked on the door and asked, how are you safeguarding against ransomware attacks? Would you have a decent answer?
That's a great way to frame it. And it's definitely something that everyone needs to look out for very, very soon. So we also have a guide available on what to expect from the Cybersecurity and Resilience Bill. A link to that guide is coming up in the chat now. Really, really helpful guide. You will want to download this guide. It's coming up in the chat right now. So Raquel, we've heard a lot about whistleblowing too. Is there a chance for more regulatory action?
Quite possibly, Naomi. That's the short answer. Currently, there's a private members bill on the table. This is not a government bill, but it does actually have relatively broad support. So this legislation would push for an overhaul of the whistleblowing regime. It's not guaranteed to pass, but Labour has signalled support for whistleblowers in the past. So, for an example of this is when they promised US Star Awards for exposing wrongdoing. So we could actually see the government either adopt that bill or introduce its own. Potential changes might include establishing an independent whistleblower office or authority, increasing awards or compensation for retaliation, and expanding the scope of who is protected. This may include volunteers or job applicants who currently aren't covered by the law. For compliance, this would mean ensuring your whistleblowing channels are really, really effective and trusted. Even ahead of any law change, for sure consider doing a refresh. Test your hotline, republicize it to employees, add an option for being anonymous if it's not already, and verify that every report gets proper attention. Culturally, senior leadership should encourage speaking up, not discourage it.
Such an important last point. If the senior leadership encourages that speaking up, I imagine there will be more of it. So thank you for that. And another big change that we're expecting soon, Sarahan, is for financial services. Can you tell us about that?
Of course. Thank you, Naomi. So yeah, we've heard in the last few weeks about the planned shakeup of the senior managers and certification regime. And just last week, they outlined plans to cut the number of roles that need regulatory approval by around 40%, to speed up approvals, digitize certain records like share registers, and to reduce some paperwork. So essentially, they recognize that SMCR, while good for accountability, has become a bit burdensome. And by simplifying it, possibly over the course of 2026, banks and financial firms will have an easier time hiring and managing senior staff compliance. And compliance teams in finance should prepare to adjust their processes. So for example, you might not need to file as many forms for certain promotions, but also be aware that reducing bureaucracy, that's not going to mean lowering your standards, because it is about efficiency. But senior managers will still be liable for failings, and that's not going away. So you're going to still want to train them accordingly.
That's really important. Thank you. And we're going to see a massive expansion in the non-financial misconduct regulations. Can you tell us more about that?
Of course. So yeah, we're expecting those rules on things like workplace culture and bullying to be expanded to an additional 37,000 non-banking FCA regulated firms from the 1st of September 2026. So in just over a year. Now, this will expand code of conduct rules to explicitly define serious bullying, harassment, and violence as regulatory misconduct and require these cases to be documented and reported on. So that means that essentially firms will be required to embed controls, training, and reporting procedures for non-financial misconduct, and expected to treat it to the same degree with which they monitor financial crime or market abuse. So that is really going to be quite a change for some firms. And it's definitely worth starting to think about now how you're going to implement that.
Well, thanks. Yeah, that sounds like it's a real significant change that firms need to be prepared for.
Yeah.
And we've covered a lot, and I really want to touch on some ideas for staying up to date and prepared for all these changes in general. Let's just ask our final poll question of the day. And it's a really kind of big question. Which compliance reform will affect you most? Employment law changes, data protection, cybersecurity, financial crime, fraud, DEI and harassment, senior manager liability, or something else? And let us know in the chat what that something else is, because we really want to hear from you. Which compliance reform will affect you most? Again, employment law changes, data protection, cybersecurity, financial crime, fraud, DEI and harassment, senior manager liability, something else. And let us know in the chat. These are all areas of compliance that we covered today. Which one affects you the most? Give everyone a couple more seconds to answer. And again, let us know in the chat if we didn't highlight something. So, wow, here are the results. 52% of you, over half, said that employment law changes will affect you the most. 26% cited data protection, cybersecurity as a compliance reform that will affect you the most. 12% say financial crime and fraud. Only 7% say DI and harassment. Only 3% say senior manager liability. And 0% said something else, but I'm hopeful that you wrote in the chat what that something else is, if anyone had that. Okay, so Raquel, you are speaking to companies all the time about managing and dealing with some of these changes. No matter what the specific issue actually is, what are your top tips for staying ahead of what's coming?
So that's a really important question, Naomi. I'd say strategic preparation and staying informed are key. I'd start by creating a compliance roadmap. So map out these expected changes in the timelines. For example, you can mark September 2025 for failure to prevent fraud if it affects you. And this is really good because it will make sure by that date, your fraud risk assessment, policy and training refresh are done. They're sorted. I'd also mark down 2026 for thinking about pay gap reporting. I'd recommend having a plan to start collecting data next year so you have baseline figures. So by visualizing it on a timeline, you can then allocate resources and just not be caught off guard.
Sarah Hannah, any tips you want to share also?
Oh yeah, great tips, Raquel. And I'd also add that many of these changes require efforts across teams, which can slow things down. So talk to HR about about the employment and DEI changes. So things like menopause plans, 0 hours contracts, harassment training. Talk to IT about the cyber resilience duties coming. Maybe conduct a joint tabletop exercise for a cyber incident to identify gaps. Talk to your CFO or finance about the resources needed to implement changes, because you might need to budget for a new compliance tool for whistleblowing or to track holiday pay, for example. And we did see in our poll that over 50% did feel that the compliance reform that will affect them most is the employment law changes. So those are definitely big things to keep in mind to start to prepare for now.
Really good point. Really, really good point. And it's also a good opportunity, I imagine, to refresh some of your policies and make sure those are still relevant.
That's exactly right. So start reviewing your policy library in light of what's coming. Do you have a whistleblowing policy? If yes, will it meet an expanded law? Perhaps update it to say we will protect anyone speaking up on misconduct, and reports can be made externally if needed to align with the spirit of upcoming reforms. And for training, I think a good tip is to plan a schedule, to be prepared, and just have a schedule in place to think about when you'll run a new training on sexual harassment prevention or a session for managers on handling flexible working requests fairly. If you handle training content, you can start to plan now for the next year or two of training, and then it's not going to come as a surprise when you need to do it.
For sure. I hear from companies all the time that it can be really, really challenging to just get senior managers to buy into the need for action and or budget. But I guess you can use as leverage the fact that many of these changes increase liability for the senior managers. So, for example, if your board knows that next year they might be personally liable if something goes wrong, they are much more likely to support robust compliance measures now. So remember on a regular basis to make sure you brief the board or audit committee about these upcoming changes. It can be a simple one pager saying upcoming compliance reforms and impact. That way, no one can say they weren't warned, and you might secure budget for necessary initiatives like new software by highlighting these looming requirements.
Right. Thank you, Raquel. And I'll also just add that monitoring regulatory and industry news is so important. So coming to webinars like ours, checking the VinciWorks blog, where we do aim to cover every compliance issue that will be relevant to your firm and industry, if we may say so ourselves, can be really helpful. The legislative process can be slow or uncertain, but regulators often telegraph their expectations in advance. And I'll just add that these are great opportunities to look at how your own team operates. A compliance program that's agile, that can roll out a new policy in a few weeks, or deliver urgent training when needed, when something new comes up, when something unexpected might be happening, and those companies will fare best. That agility usually comes from having a strong foundation, like an established policy management process, a good learning management system for training, and things like that, so you can plug in new content quickly as it comes up and as things change.
Thank you. That's really, really excellent advice. And I just want to remind everyone here that VinciWorks does have training available on every compliance topic that your firm needs to know about. And we are, like Sarahena said, monitoring these changes and preparing for them often years in advance. So by using our training, you can expect the latest regulations to be updated and included, and to have modules and courses relevant to these legislative developments ready for whenever you need them. So just write demo in the chat and we'll show you our latest courses and how to manage it all. It could be on your LMS or on ours, but either way, really, really effective. Now, we've covered a tremendous amount of ground today. Data Use and Access Act's tweaks to GDPR, the Employment Rights Bill, sweeping protections, the new failure to prevent fraud offense, developments in diversity and inclusion like the 4 Women Scotland ruling, all the way to upcoming cyber and whistleblowing reforms. It's clear that the first year of Labour's government has already changed the compliance landscape, and that trend will likely continue for the rest of this parliament. So before we close out, I'd like to get some final thoughts from our experts today. Raquel, what's your takeaway for our audience?
Good question. So honestly, I think my takeaway would be just stay nimble and don't get complacent. The regulatory direction is really quite clear. More accountability, more transparency, more enforcement. Definitely use this time wisely to audit where your compliance programs stand. If there are any areas you've been meaning to get to, now is definitely the time. Also, keep an eye on the VinciWorks blog. We really make sure to bring you the latest changes, even those that happen quickly, unexpectedly, and having a pulse on things just helps you not be surprised.
Yeah, I will definitely agree that we absolutely do that. Every morning, we're monitoring hundreds of news sources and regulatory updates and distilling it down to what you need to know and do. And also look out for our email summaries in your inbox or in LinkedIn also. Okay, Sarahena, what's your biggest takeaway?
Thanks, Naomi. So a lot of great advice today. And I would just say that I would encourage companies to embrace the role of compliance as a strategic advisor in your organization. With all these changes, boards and executives will be looking for guidance. So if you can say, here's what's coming and here's how we turn it into something positive, or at least here's how we manage it smoothly, you elevate the perception of compliance from rule enforcers to essential partners in the business. I would also just say that it's important to collaborate with your peers. None of us have all the answers, but together we can share solutions and interpretations through webinars like this. There are a lot of things going on, so many changes in the works, and we are all navigating this new territory together.
Great points. Absolutely. And actually, I just wanted to put a quick plug. We have an industry group specifically for money laundering. If you're an MLRO or a compliance officer focused on AML, let us know in the chat and we'll be in touch about our regular core group meetings. They're a fantastic group that gets together and really has formed kind of a community that supports each other, just like Sarahana, what you're saying. So write AML into the chat and you can learn more about the core group and possibly get an invitation to our next meeting. So I want to thank you both, Raquel and Sarahana, for lending your invaluable insights today. Your thoughtful analysis really helps bring clarity to very, very complex issues. Now, as always, VinciWorks will continue to provide updates, guides, and training materials on all these topics. We hope you found this session useful in mapping out the past year's changes and preparing for what's coming. Remember, the key is to stay informed and proactive. A year from now, we'll likely be discussing how well we adapt to these changes and whatever new surprises come our way.